Everybody has a right if they're a responsible adult.
The right to keep and bear arms shall not be infringed.
This is a case that's been bounced around back and forth throughout the court system.
Major Second Amendment case.
A Supreme Court shift that could rewrite gun rights forever. Across America, gun owners are watching something historic unfold, and this moment feels different. The Supreme Court's Bruen ruling has become a legal weapon, used to strike down state bans on suppressor purchases and possession. This is no longer speculation. Real lawsuits are now moving through federal courts, and the outcome could permanently alter firearms law in the United States. If these cases succeed, they could force states to explain why they have the right to criminalize equipment that improves safety, accuracy, and self-defense. That is why support and awareness matter now more than ever. So subscribe, like, and share so responsible American gun owners never miss a critical update. Chapter 1. A national fight begins. A new legal offensive has begun that challenges the authority of states to ban suppressor ownership. This combined lawsuit has gained attention because, for the first time, courts are being pushed to directly apply the modern Supreme Court standard. This moment has sparked national interest, and gun owners are watching closely. Some believe this could become the ruling that reshapes the Second Amendment in real time. Combined cases create a unified legal attack. Focus directly challenges state authority. Federal courts were forced to examine the Bruen standards. Momentum spreading in multiple states. This moment marks a turning point in how courts interpret the Second Amendment in the real world. What was once a theoretical legal debate is now translating into action that affects millions of firearm owners. Whether someone owns a suppressor or not, everyone can feel the momentum shifting toward constitutional restoration. And this case is only the first warning shot in what could become a nationwide legal revolution. Chapter 2. How Bruen changed everything. The Bruen decision is now the foundation that shapes nearly every Second Amendment court battle in the country. It removed vague judicial tests and placed a clear requirement on states to prove their gun restrictions align with American history. This ruling reversed decades of interpretation and placed the burden back where the Constitution intended. The government must prove historical firearms restrictions. Modern legal balancing tests are no longer valid. No rulings can stand without historical grounding. The Constitution is the controlling standard. For gun owners, this ruling may end up being the moment where the wall separating state restrictions and constitutional freedom finally begins to crack. Courts are no longer accepting evidence that is unrelated to historical context, and that shift could unravel laws that have stood for decades. This is why even states far outside Illinois are paying close attention. What happens here could decide how firearm laws are interpreted across the country for years to come. Chapter 3. The shock ruling from the lower court. Many were surprised when the district court sided with the state instead of the plaintiffs. Instead of requiring Illinois to prove historical support for a ban, the court demanded the plaintiffs prove suppressors existed or were recognized during the founding era. This approach left many legal analysts concerned. The court shifted the constitutional burden. The state avoided providing a historical justification. Plaintiffs forced to prove suppressor history ignored the essential direction of the Supreme Court. This approach changes the legal battlefield completely because it removes the emotional and speculative arguments that have dominated Second Amendment cases for decades. Courts must now prove that there is real historical justification behind firearm restrictions, not just modern policy preferences. If this standard holds, it could permanently limit how far states can go when attempting to restrict the tools Americans use for self-defense. That is why this case matters far beyond suppressors alone. Chapter 4. The appeal heading upward. The plaintiffs wasted no time and moved the battle directly to the 7th Circuit Court of Appeals. This is now one of the highest-level suppressor cases in federal review. If the appellate court reverses the lower ruling, the effects could ripple across the entire country. Appeal filed quickly and aggressively. The case has now been elevated to federal review. National legal attention is building rapidly. It could establish one of the most influential precedents. The significance of this lawsuit lies in what it represents, not just what it asks for. It challenges the long-held idea that suppressors are unusual or dangerous, instead arguing they are normal, safety-enhancing firearm accessories. If the court agrees, other bans could quickly lose their legal footing. Hundreds of thousands of gun owners could instantly find themselves with stronger constitutional protection than ever before. That is the kind of ripple effect lawmakers are quietly nervous about. Chapter 5. Advancing rights along with technology. The plaintiffs argue that American rights have always evolved with technological development. Founders could not know about smartphones, internet vehicles, or modern firearms, but rights still apply to them. Suppressors are being presented as modern tools that enhance effectiveness and safety, which should fall under the Second Amendment. Rights apply to new technology. Suppressors enhance responsible firearms use. The Constitution does not freeze in time. Other amendments have already evolved. What makes this moment especially powerful is that states that once believed suppressor bans were untouchable are suddenly without a stable legal ground. If one federal court decides these restrictions violate the Constitution, legislators around the country may face a wave of copycat challenges. The laws that seemed permanent could crumble one case at a time. That possibility is why legal scholars and state attorneys are watching this situation closely. Chapter 6. How the state defends the bans. Illinois has taken the position that suppressors are optional accessories rather than protected components of a firearm. The state claims they are not necessary for operation and therefore not covered under the Second Amendment. The lower court accepted this interpretation, which became the foundation for dismissal. The state defined suppressors as non-essential. The court accepted the argument without burden. No historical evidence is required from the state. Plaintiffs were forced to attack the framing directly. The shift toward historical standards creates a future where gun owners no longer have to defend themselves against vague claims or hypothetical scenarios. Instead, the government must prove its authority with real historical evidence. That transforms the legal balance from government control back toward individual rights. And if this approach becomes the national norm, many modern gun restrictions may not survive long-term. Chapter 7. Why the case could reach the Supreme Court. There are now multiple suppressor lawsuits unfolding in different states. If appeals courts across the country issue conflicting rulings, the Supreme Court will be forced to step in. With the current composition of the court, many legal observers believe a 6-3 outcome is highly likely. Multiple states face ongoing legal challenges. Conflicting rulings would demand review. The Supreme Court could resolve national uniformity. The outcome could define the suppressor law for generations. Lawmakers now see that passing more restrictions may not be enough. If courts keep applying Bruen faithfully, laws that were once seen as permanent could collapse under their own lack of historical grounding. That could reshape firearm policy nationwide through legal pressure rather than political negotiation. And many elected officials know that the clock is already ticking. Chapter 8. The domino effect in motion. If one federal circuit rules that suppressor bans violate the Constitution, other courts will be forced to address Bruen consistently. A single victory would give attorneys everywhere a powerful precedent to cite, and state-level bans could begin falling rapidly. A win creates national momentum. Other states would lose legal foundation. Arguments spread across federal courts. Restrictions begin collapsing state by state. Public awareness is turning legal cases into national conversations, and national conversations into political pressure. When millions of people begin paying attention, lawmakers feel the spotlight more directly than courtroom arguments alone ever could. Every update in this case brings more people into the discussion, and that increases the momentum toward broader recognition of constitutional rights. Awareness itself becomes part of the legal and political power structure. Chapter 9. What is at stake? For everyday gun owners, millions of responsible gun owners argue that suppressors promote safer shooting, not abuse. Suppressors reduce hearing damage, improve control, and help shooters protect themselves and others. Many believe states are criminalizing equipment that makes firearm use safer, not more dangerous. Suppressors protect hearing and safety, improve precision and firearm control, do not increase crime or threat, benefit lawful citizens rather than criminals. Even without a final ruling, this case has already sent a message. States can no longer assume that courts will simply accept restrictions without demanding proof. That reality forces governments to prepare stronger legal reasoning than they have ever needed before. If they cannot, these laws may fall faster than anyone expected. The process alone has already shifted the ground beneath every state that enforces suppressor bans. Chapter 10. The road ahead. The suppressor fight is far from finished. The case now sits in the 7th Circuit, where judges will determine whether the lower court misapplied Supreme Court direction. Oral arguments and filings continue, and every development increases the pressure on both sides. Briefs filed and review underway. Multiple states are monitoring the proceedings. National advocates are preparing responses. Decision expected to influence future litigation. This case represents more than one legal fight. It marks the beginning of a larger correction in how the Second Amendment is interpreted across America. The arguments being tested today could reshape future rulings, future legislation, and the rights of generations to come. That is why this moment feels larger than one state or one court. It signals that the country may finally be returning to the original meaning of the Constitution, one ruling at a time. The fight for suppressor fights is just beginning. The suppressor cases now working through the courts represent more than a debate over firearm accessories. They represent a larger question about how far government power can reach into the rights guaranteed by the Constitution. With Bruen setting the standard, more Americans are demanding that the burden remain on states to justify restrictions through real historical tradition. As this battle continues into higher courts, its outcome could set the direction for future gun rights litigation across the country. Make sure to subscribe, share, and stay engaged because informed Americans are the strongest defense against the quiet erosion of fundamental freedoms.